But before we even get to that, I just want to
Yeah.
be clear, right? Because when
Mm.
we're talking about a revocable trust, we're not
Yes.
talking about it being set up for income tax purposes. We're
Sure.
not talking about it being set up for estate tax purposes. So it
Mhm.
does nothing for either one of those purposes, right? It's truly a probate vehicle.
Welcome back to the US UK Tax Talk podcast. I'm Aidan Grant, a partner in the tax and estate planning team of Collier Bristow. Today, I have the very great pleasure to be joined by Bari Zahn of Zahn Law Global, a US attorney specializing in a wide variety of tax and estate planning matters.
Hello, Aidan. How are you? It's great to be here.
I'm great. This is the first time that we are doing this podcast in this format. So I am one, very grateful for you for being the guinea pig, and two, feeling full of confidence that we could not have had a better, more professional person to do it. So I thank you very much in advance.
Woohoo. All right. I'm excited.
Yeah. So today we're going to be looking at real estate and thinking about the structuring, funding, and holding of real estate, which is one of the most common asset classes that high net worth individuals need to think about. And in both the US and the UK, real estate has proven historically a very lucrative and stable asset to hold. So lots of people have it, but the way in which the US and the UK think about the taxation of real estate and thus think about the holding and the structuring of real estate can be quite different. And what Barry and I want to talk to today is where those differences arise and how we try and square that circle. And so what we're going to do is we're going to take it in largely two stages. In the first part, we're going to think about Barry's client in the US who is thinking about buying US real estate, and maybe that person has a lingering UK tax exposure. And then we're going to flip it on its head, and we're going to talk about the American who's come to the UK and what I, as an English law attorney, thinks that person should be doing with their planning. How does that sound, Barry?
That sounds perfect.
Wonderful. It's probably worth starting from the position of thinking, what are the theoretical ways that one can hold real estate? And then we're going to dive into each one of those in a little bit more detail. From my perspective, knowing sort of the American market as I have, there are really three different ways that one might hold real estate, and you can hold them as a combination of some of them. Someone might choose to hold their real estate in their own name. Someone might choose to hold their real estate through a company, and they might choose to hold their real estate through a trust type structure. Thinking about that direct ownership first, what are some of the reasons, Barry, why I might choose that as a first option? Why might I choose to hold real estate in my own name?
Just to start, for clarification, we're talking about a UK citizen that's not domiciled in the United States for estate tax purposes and is not a for income tax purposes is not a US person, let us say.
Correct. Yes,
So
that is correct.
just to be clear for everybody that's listening. Holding real estate in your individual capacity in general is not something that we would recommend. However, right before we get into that, um, certainly both from an income tax perspective and from an estate tax perspective, it's simple. And I think that if somebody is not looking for complexity and maybe is holding the real estate not for business, not for investment purposes, but really is just looking to use it personally and potentially it's the real estate is not worth a significant amount, and so they're not so concerned about estate planning and perhaps could purchase insurance for estate planning purposes. Then I could see a client maybe wanting to hold the real estate in their individual name, um, but that doesn't usually happen all the time, and then doing that also subjects whether they're US or not, subjects the individual to probate in the particular state, which is depending on what state you're in, could be a nightmare process. I'm in New York, it's certainly not fun. That would be I think one of the reasons why you may want to hold real estate in your individual name.
What is interesting, or what I find is interesting about the way in which a lot of US structuring applies for tax purposes, is that what you often try and get back to is the fact that from a tax fictional perspective, you are treated for tax purposes as if you hold the real estate in your own name. And we'll see that maybe in some of the alternative holding structures that Americans like to use, like LLCs and revocable living trusts and those kind of things. So from a tax perspective, I think Americans like the idea of holding real estate in their own names, but it's just that actually doing that from a sort of an actual perspective, that's what throws up some of the pitfalls that I think you're talking about, isn't it? It's the non-tax reasons why individual ownership is problematic.
Absolutely. Yeah, because I think even from an American perspective, some of the considerations, as you said, are still the same. We're still thinking about probate. We're still thinking about asset protection, where insurance may come in on the asset protection side that still doesn't deal with the probate side, especially if you have real estate, whether you're, again, non-US or US in multiple jurisdictions throughout the United States, then we would like to recommend some sort of revocable living trust. But as we've had conversations before, and we'll get into that, that can pose some problems from the
Yeah.
UK side.
And from a kind of a purely administrative perspective, and neither you or I are, I think, real estate lawyers, so it's not perhaps our speciality. Is there any convenience in the purchase or the sale process from holding a property in one's own name rather than holding it through a structure? Does it make the due diligence or the paperwork or any of that part of it any easier?
Yeah, no, that's an excellent question. And the answer is like any good tax lawyer would say, it depends, right? So in general, it doesn't really make it that much easier, except if you are purchasing a cooperative, a co-op in the US. And then there's definitely more um, rigidity in terms of putting that asset into some type of trust structure or corporate structure. Although these days it's becoming a lot more easier to do so.
I mean, what listeners will quickly come to terms with over the course of this episode is what I'm going to be doing is pushing back on all the ways in which Bari says she wants to structure her real estate, because from a UK perspective, structures tend to mean tax complexity from a UK perspective. And we generally like holding real estate simply. So when I start with holding assets in an individual's name, it's not just because it's the simplest conceptually to deal with, but also from a UK perspective, it's probably going to be the most tax efficient, because you are just an individual living in a country trading asset class one, say cash, for asset class two, property. I was owning cash, I am now holding real estate. Aside from perhaps at the periphery some degree of tax credit exposure, where if you were holding cash in the US, you might pay or not pay US estate tax, whereas if you were holding real estate, you're probably more likely to pay US estate tax, in that kind of double taxation realm, which maybe we'll have time to get back onto in this episode. Maybe there's some discrepancy at the borders, but in terms of the way in which that actual purchase can have real life immediate UK tax consequences, that's going to be a lot simpler in an outright ownership model. Talk to me, Barry. You already mentioned the magical phrase, the revocable living trust. You've also teed up already in one of your previous comments about why people like to use the revocable living trust. It's why they're one of my favorite topics, so I try and squeeze them into every episode. Why do Americans, particularly with, say, their real estate, like holding them sometimes through living trusts?
Right. Well, like I said, from the first perspective, a revocable living trust really avoids probate. And that's one of the main considerations that we would look at. And especially if you're dealing with real estate that cannot be transferred by operation of law, like a brokerage account where you just put a beneficiary on the account. So certainly our recommendation for any U.S. clients that hold real estate would be to put them into a revocable living trust. And certainly if they have real estate in multiple states throughout the United States, because you'd have to have your probate administration in your state of domicile, or if you're not a U.S. person, then that you'd have to figure out where you'd have your initial probate, and then have to have ancillary probates in each of the various states. So certainly, holding assets in a revocable living trust is very beneficial. And also further on, upon the grantor or the settler's demise, then that gives an opportunity potentially to have ongoing dynasty trusts and legacy planning long term. So it's definitely something that we look at for both US and it's the same for non US persons as well.
Oh, I'm aware. I have plenty of clients living in the UK who've told me they've got their US property in a living trust. I'm well aware that Americans are happy to do it for non-American residents. I don't know the specific rules in New York because I can't remember which of the rules I know and which states they derive from. But I know that in certain states, the level of probate fees or the complexity, the time that gets involved in the probate process can be relative to the value at stake, etc. And because the main, let's say the family home is quite possibly going to be the largest asset or one of the largest assets, that might be sort of quite impactful. Is the probate process for real estate versus, say, a bank account any more problematic, or is it just the probate process at large is horrendous and so we want to avoid it however possible? Is it any worse for real estate?
Right. Well, first of all, for a bank account, there really is no probate if you've properly marked your beneficiaries on
I was going to come to that in a second.
right, the designation forms, then you
Yeah.
would not have probate. So truth be told, once you're in probate, you're in probate. The only difference is what's the level. There is, different states have small probate proceedings, but most of our clients are not. I mean, it's $50,000 or under in New
Well,
York. So our clients are not dealing with that.
probably not much real estate you can get in Manhattan for $50,000.
Yeah, no. Maybe the real estate called like a burial plot. That's about it. But
Maybe hard to live in it. But the point you made is right, which is one of the things I spend not inconsiderable amount of time talking to Americans about is whether there are other ways to avoid probate, like jointly held assets, or transfer on death arrangements. So designating your beneficiaries of an account, for example. And
right.
with some success, sometimes I can persuade people that if we can use a transfer on death arrangement to avoid probate, then and it has a much beneficial tax status in the UK, then I'd rather that route use than the living trust option. But this is where please tell me I've been wrong in my entire career. It's not possible to put any kind of automatic beneficiary designation over a parcel of real estate. Thus, that is why people put them in living trusts.
Well, actually, if you have a husband and a wife, a husband and a
Yeah.
husband, a wife and a wife, right? If you
Mhm.
have married couples and they're holding the property as in essence joint tenants with rights of survivorship, it's called tenants by the entirety in the US. Then if the first spouse to pass away, well, first of all, they would pass automatically, but also the first spouse to pass away, depending on what the other documents say, we potentially could avoid probate. But it's not something that again that we would generally recommend.
Hot off the press, for anyone really looking to find the answer, Barry will be delighted to have that discussion with you afterwards. Of course, in this circumstance, what we're talking about is a transparent structure for US purposes. We've been talking about a grantor trust for US purposes. Of course, we could be talking about holding real estate through an irrevocable trust or a non-grantor trust, a completed gift trust, whatever of the terms we want to use. From a holding perspective, that has certain benefits. From an American tax perspective, there are certain consequences to holding real estate through an opaque structure like a non-grantor trust. I just want to point out at this stage that everything we've been talking about is on the basis that it is a transparent structure. If a UK citizen living in the US is thinking of buying property and transferring it into an irrevocable structure or a non-grantor trust, the potential UK tax consequences could be a lot more severe. And that is absolutely the point at which that person needs to be taking UK advice, particularly if they have been in the UK in the last 10 years, because there could be some immediate UK tax consequences to putting value into a trust when you're potentially still inside the UK tax net.
Absolutely, and we'll get because you and I have talked about that, and we'll get to that. But so that's a great point. But from the U.S. perspective, when we're looking at that, when a UK citizen is investing in the U.S. in real estate, and we recommend looking at setting up what we're going to call a basic estate tax plan. We would say have a pour over will with a revocable trust, and then we would work with you to see if you from a UK side could look at that revocable trust as transparent. And let us say for a moment we can get there, and based on our prior discussions, we think we might be able to with some creative writing. But just to be clear for the viewers that when we are talking about that basic planning for a UK citizen that owns that US real estate in their individual capacity through this, in essence, right, through a revocable trust, and we look at it like they're owning it individually, and that's why, from a US perspective, it does not impact them from an income tax perspective, and it
Hmm.
does not impact them from an estate tax
Hmm.
perspective or a gift tax perspective.
Yeah.
Because from a US perspective, it's as if the trust is not there and it's as if they own the real estate directly. So if they should pass away holding that real estate, um, and we don't do anything else, they would only have a $60,000 exemption for estate tax purposes. And, that's where we say, well, perhaps in that situation, purchasing insurance might
Hmm.
be an option to still
Hmm.
keep it simple.
Or purchase your real estate through something that blocks the estate
Oh,
tax.
well, then now we're getting into blockers and more and right, more intricate
No.
conversations of
Yeah.
structures that make your hair go up on the UK side.
Yeah, and I fully appreciate that I'm the one causing the difficulty here. I'm hoping, Barry, you will only do me the courtesy of extending that reciprocity in the other half of this episode when you start causing my life to become complicated. What I was just merely alluding to is there are ways to be sort of more sophisticated in estate planning, and Barry and I have, viewer be aware, in a separate discussion, spent great time talking in detail about the various intricate, specific ways in which if one puts A on top of B, between C, alongside D, and underneath F, would you be able to block every single tax from arising? And the answer is, if you give us the right facts, we might be able to present you with the perfect solution, but you've got to come at us with the right facts. So if someone listening to this podcast wants to write in with a fact pattern that they think is worthy of a perfect structuring scenario, we'd be delighted to do it. And then we like nothing more as tax and estate planning attorneys. What I want to come to, Barry, is number 3 on my list of ways in which Americans like to hold real estate, which is, I think, less of a problem for the UK person, but in the wrong circumstances becomes the most tax inefficient, which is where Americans like to hold properties through companies. And here I'm largely focusing on limited liability companies, or LLCs. Can you talk to me and to the viewers about what are some of the reasons why someone chooses an LLC as a property ownership structure rather than, say, a living trust?
Right. Well, first of all, an LLC and a living trust are completely different. So if you hold something through an LLC, just sticking with the probate perspective, that does not avoid probate. So I find probably the number one misinformation when UK residents, citizens, and non-US people in general are purchasing real estate in the United States. They'll have their broker, and the first thing the broker will say is, "Oh, put it in LLC." And it's like, wrong, right? And it's not that it's completely wrong, because we may ultimately and very likely, depending on the structure, end up with an LLC in that structure. Likely the LLC is all the way at the bottom and then the real estate is below that. But if you just immediately set up that LLC, it causes problems, and I'll get into that. And also, if you are going to use an LLC, the steps, how you set it up, when you set it up, how the money flows in and down, super important. So, an LLC, one, if it's at the top, causes problems, as you know, from a treaty perspective, and you'll get into that. But also from a U.S. perspective, if you wholly own an LLC, the LLC is disregarded from an income tax perspective. It does not exist, similar to the Rev Trust, but it doesn't give you the probate protection, and it doesn't help you from an income tax perspective, a gift tax perspective, and estate tax perspective. So it may help you from a gift tax perspective. It's if it's owned with two people, but it's not clear, so I won't get into that intricacy right now. But so it's I would say it's the biggest fallacy that I find, and it's unfortunate because many times what happens is I'll have somebody that's already put the contract for the purchase into the LLC, and then they'll say, well, can we transfer it? Can we transfer it after the sale? The answer is you can, and you actually can transfer it after the sale without income tax. However, there is something called FIRPTA, which is the Foreign Investment and Real Property Tax Act, which affects non-US citizens that are purchasing and non-US people that are purchasing real estate. And although you can, if you transfer it immediately afterwards into another structure, and there's no appreciation in the property, you can transfer it without income tax, but you have to do a whole non-recognition filing under the FIRPTA rules, which is expensive and time consuming. And the only one who really makes money on that are the lawyers. So, before doing that, before putting it into an LLC, I would say definitely speak to you, on the UK side or someone like me on the US side.
I'm actually usually remarkably sanguine if someone wants to put their property into an LLC if they're living in the US at the time. Where I get very exercised about Americans using LLCs is when they are UK tax resident, about which I'm certainly hoping we are going to have an episode in the future because it definitely deserves a podcast in its own name, in its own right. The main time or the main reason why I hear about Americans putting their properties into LLCs is for liability limitation purposes, is because I have this impression, because I get told this by my clients, that there is a fear that if you own your property in your own name and someone trips on a flagstone in your property, a tradesman or a gardener or a guest, they will sue you. They will take all of your money because the Americans are a very litigious community. But if you hold your property through a limited liability company, it is still a company. For tax purposes, it might be disregarded and taxed as a partnership. But for liability purposes, it still had the corporate veil. And so sometimes wealthy Americans will hold their properties through LLCs to give them that protection in a way that I guess insurance doesn't. Is that a thing that you see in your practice?
I do, and so part of that is true in terms of limited liability. One, absolutely, an LLC gives you limited liability in the situation that you described. Somebody trips and falls, and they're now suing, and they're limited in that situation to whatever assets the LLC holds. First of all, the assumption there is that the LLC has been respected. So the corporate form has been respected, meaning that you really are treating the LLC as if it's a separate juridical entity. Bank accounts are separate. You're not using it as left pocket, right pocket. And so you're respecting the corporate form. If that doesn't happen, then there is a situation, right, where potentially you could pierce, a creditor could pierce the corporate veil. But putting that aside, then yes, you have limited liability there. And insurance, potentially, depending on how much insurance you have, also gives you the same liability coverage and maybe even more, because I would say maybe you need both, right? Because in any way, if there is some possibility of piercing the corporate veil, doesn't hurt to have that insurance in addition. However, what folks don't realize, and this is where asset planning protection comes in, if I'm holding an LLC and that LLC has property, but somebody, let us say I'm driving and I kill somebody, if somebody now goes to sue me in my individual capacity, now everything that I own still could be attached by a creditor. So it
Hmm.
does not give you any protection from liability from the top down.
Mm.
So this is where asset protection planning actually comes up. And many times we'll do that asset protection planning below whatever um, structure that we have, which could be a rev trust and and a foreign corporation and then a U.S. corporation and then below that an LLC and below that some family limited partnerships and then it gets really fun. But yes, the LLC does give the holder limited liability for whatever, in general, for the assets that are in that entity, and that is one of the main reasons that we use it. And we generally recommend that, again, depending on your risk tolerance, for every piece of real estate that you have, in general, we would recommend holding each one in a separate LLC. And that's why I said usually if we have that LLC, it's at the bottom of the structure because many times above the LLC, we may see a US corporation. Again, depending on what in particular the non-US investor is going to be doing. What are the activities that they're going to be engaging in? And also, what are they considering? Because sometimes income tax planning, right, conflicts with estate tax planning. What's their main goal? It may be gift tax planning, which the rules are different depending on what we're talking about.
Yeah, the person who wants to just buy their Long Island property as their US piece of real estate that they're going to live in, they're probably not going to rent out while they're not there. That's quite different to the person who's creating a multi-industry sector holding structure, which is going to have both commercial and residential. As the residential is going to be rented out, and then it's a more of an investment vehicle. And what works, as you say, for one may not necessarily work for the other. Let me ask you about one other aspect of LLCs, which I note on the 24th of March, as we are recording this, may still be in flux. Corporate transparency. Am I right? Have I heard it correctly that the US is perhaps, shall we say, not quite so hot on enforcing its Corporate Transparency Act in 2025 as perhaps it was, as it may seemed it was going to be in 2024? We don't have quite such the same risk of owners of companies having to publicly disclose their ownership to the public.
Well, the CTA, the Corporate Transparency Act in the US has gone back and forth, and there's been, various cases, and it stops and it starts, and the Treasury Department under FinCEN is where you have to do the reporting, has said they will enforce it, they won't enforce it, and we're recommending that our clients file. Our law firm has filed, and we are recommending filing. And in New York, in particular, and in many other states, they have the filings. In New York, filing becomes effective in 2026. So we are recommending it, but the filing is not a public filing. It's going to the Treasury Department, and quite frankly, the IRS the Internal Revenue Service has almost all, if not all, of that information anyway. It really is duplicative. So we're not sure why it is that this is being required, but our recommendation is that, that our clients file, and we have been filing for them, and it's very inexpensive to file.
Does that include LLCs? Are they caught by the rules on transparency?
Yes. So every entity that has to have some sort of filing to become an entity.
Mm-hmm.
So right now, trusts do not have to do a beneficial reporting. However, a trustee that has control over an entity below that trust does have to do reporting. So everything other than a partnership, because a general partnership is more like a common law entity, it doesn't have to be filed. And the trust itself, if you just have a trust without any corporate entities below it or any entities that need filing, but you wouldn't need to file. But yes, an LLC definitely falls within the CTA filing requirements.
Barry says, get your filing in on time. I know some other lawyers who may be being slightly more circumspect about that point. Right. What I want to do is I want to sort of take a pause there on the part one and think about part two, because I want to flip Barry, you and me around, and I want to talk to you about the American that's going to come to the UK and how the American is going to want to invest in their real estate. And what we're going to find is Barry's now going to play the bad cop and tell me all the ways in which what I want to do is going to be wrong. So in this scenario, what I am thinking about is an American citizen comes to the UK, is a UK tax resident. Let's say, for the sake of argument, because it is going to become relevant later, they have a non-American spouse, and they want to buy their first home in London. So what are the ways in which we would be typically advising that person? From the UK perspective, the actual recommendations I might make are largely much more straightforward because of all the reasons why I said in the first half we want people to own assets in their own name, because the UK tax system largely penalizes any approach that isn't holding real estate in your own name. So I'm going to go through sort of with Barry one at a time, and I'm going to offer up, well, what if the person wanted for some reason or another to hold property in this way? What would the tax consequences be? But none of them are largely going to be my recommendation, because my recommendation is going to be hold it in your own name. But let's just say, for the sake of argument, Barry, that a client of yours comes to the UK and they want to put a foreign piece of real estate from the US perspective. They want to put that real estate into trust. What are some of the tax consequences that you want to be making sure to be talking to them about when thinking about that foreign trust and putting real estate into it?
Well, I don't want a US person to put any assets into an offshore trust, into a non-US trust. That, from a US perspective, can be very, first of all, cumbersome from a reporting requirement, a tax obligation reporting requirement. And in addition, it could cause significant problems for trusts, especially if there is income being generated from the trust offshore and that income is not being distributed out to the US people annually. Then those US people will be subject to something called these very bad throwback rules, which I'm not going to try to explain them now because they're too intricate, but suffice
Undistributed net income, UN.
undistributed net, right. And so when a US person, when income is building up offshore, and then let us say the US person tries to take that out, take distributions out, from a US perspective, the IRS says, "No, no, no, very bad. You shouldn't have kept that money offshore, and we're gonna treat you as if you when you take it out, that you took it out from the earliest time you could, and we're gonna impute a penalty and interest and tax you at the highest rate, from all the way, back from the beginning of when the entity was set up." And so, in general, to avoid that, one of the ways to avoid that, at least on the bad income tax side, is to at least make sure that if there is, let us say, income being thrown off that real estate, that there is at least annual distributions out, and that would avoid these harsh draconian throwback rules. But you still have the reporting rules. So,
The way in which I can see this scenario likely happens is not that someone comes to the UK and thinks, I want to buy a property and I'm going to stick it in a trust because, hey, that's in practice what's going to happen. What actually is more likely to happen, and the way in which this scenario arises inadvertently, is, let's say, a wholly, and this is deviating from my hypothetical scenario, so allow me the side discussion, is that maybe a wholly UK domestic plan is being put in place that might involve real estate in trusts, maybe something old-fashioned, maybe a grandparent is making some gifts, and one of the grandchildren happens to be an American. And now we have an American beneficiary of a foreign trust from the US perspective. And for that American beneficiary, we now have UNI and throwback taxes and those kind of things. I suspect your words, Barry, are absolutely sacrosanct. You are absolutely correct. And I think this scenario is absolutely a reason why an American grantor coming to the UK shouldn't be putting these properties in trusts. That's less likely to happen because a UK tax lawyer or a UK estate planning lawyer is probably going to dissuade them for other reasons. But this is the part where I want to say, if you have an American in the family, make sure that you are taking separate US advice on any kind of planning you are doing, particularly if it involves trusts, because that American beneficiary's presence within the trust setup, be it as a trustee or as a beneficiary, could potentially have quite adverse reactions for that beneficiary, either from a reporting or, at worse, from a tax perspective.
yeah, no, absolutely. I mean, certainly we get those situations, right, where the client comes to us and says, "Oh no, right? Here I am. I'm in the U.S. I'm a beneficiary wherever the trust is outside the United States, and then we have to figure out, can we cleanse it? Can we purge some of the income out to the non-U.S. people? Can we, figure out another possible solution in that situation? So absolutely, anytime you're planning with U.S. beneficiaries, so important to speak to someone on the US side and vice versa. I mean, anytime we're doing planning, um, and we have assets in the UK or beneficiaries, trustees, whatever it might be, the first thing I always tell clients is we absolutely cannot do any type of planning unless we have counsel on the other side in that jurisdiction, competent counsel that understands cross-border. Because I think what happens many times is clients will use their accountant, and many times accountants are very local and they don't realize the implications when you're working cross-border. So it's so important to have someone like you on the other side of the Atlantic helping me.
Could I take out some real estate on the side of your building, just sort of promoting that message? Barry says, make sure you take separate UK advice where there's UK people involved. So the second of the three UK parts is corporate ownership, which again, for business purposes, trading purposes, there are lots of very good reasons why you create business investment, property investment companies, etc. But sometimes we do get asked by Americans, because maybe they have this LLC mindset, thinking I should be purchasing my property through a company, right? Or, shouldn't I? To which there are just two things I want to flag before, Barry, I sort of throw it over to whether you think there's anything else from an American perspective that someone needs to be aware of. One is, to an American, if you're thinking of owning property through a company in the UK, the UK has something called the Annual Tax on Enveloped Dwellings, or ATED, which is a flat property tax that is levied every year on companies that own residential property worth more than £500,000 where that property is not rented out. So if you own property, and when I say rented out, I mean on an arm's length commercial basis. So if you own property in a company, that property is a UK residential real estate, that company is going to have an ATED charge every year. And that ATED charge can run into the thousands, into the tens of thousands every year for the pleasure of holding a property in an enveloped vehicle, i.e. a company. So the ATED charge alone, which was introduced about 10 to 15 years ago, is often dissuasive enough for people. That's why they introduced it. The second thing is that the UK, for the last couple of years, has had a public register of ownership of UK real estate. So if you own UK residential property, whether you hold it in a UK company or in a non-UK company, there is a publicly accessible register of who owns that real estate. It's called the Register of Overseas Entities. And unlike, Barry, with your Corporate Transparency Act, where it is not open to the public, ours is open to the public. And people need to be very, very mindful of the Register of Overseas Entities, because people will find out who the ultimate beneficial owner of that non-UK company is, for example. There are a couple of ways where you can avoid certain pieces of information being kept off the register if you have the property company structured in a very particular way. But the UK, like a lot of the world, and it's nice to see the Americans are slowly catching up, is moving towards a transparency or beneficial ownership status where they don't like the idea that a wealthy individual can hide their identity or the ownership structure of assets. And that applies particularly now in the UK to real estate. So if you want to hold your property through a company, there are tax consequences to doing so. But one of the things that you will not get these days is a privacy benefit, which is something that people used to argue for quite a lot with companies.
When you're saying residential real estate, if a US person is purchasing multi-unit residential real estate
Mhm.
that they're using for business purposes, does it apply to that as well?
When you say they're purchasing multi units, do you mean if you bought like a block of apartments, or do you mean if I bought like commercial real estate?
Let's say you bought residential apartment buildings, but they're residential, they're not commercial. And the thought is that I'm really looking more to be engaged in a real estate, an active real estate business, for example, in the UK.
Well, in that scenario, From the tax perspective, from the ATED perspective,
Right.
you wouldn't be paying, you'd be claiming relief from the ATED
That's what I
charge because
thought. Okay.
you are not using the property for your own purposes. You're not renting it to a family friend. You are trading in that property. You are, or you are investing in that property by renting it out on a third-party basis. Then you're fine. From a public ownership perspective, no, you haven't. I don't believe you have avoided the privacy benefits.
Right.
If it's a UK company, irrespective of what the property owns, the UK has a public register of ownership. If it's a non-UK company, I would need to check the specific rules again as to what counts as residential property. You are right. There will become a point at which a property is not residential anymore. It is mixed use or it is commercial in nature. But fundamentally, if we're talking about what someone would think of as a residential property, then they need to be aware of the consequences of it being held through a company.
Right. But just like you were asking on the US side, if I'm purchasing a piece of, if I'm purchasing an apartment in London, I mean, and I'm not renting it and I'm just going to use it, then the only thing in my mind, the only reason that I'm wanting to put it in entity is because of liability. And then I would think it would just be easy, just like I do in the US, just get insurance.
Yeah, exactly. And then the insurance option I would say in the UK is more of the no-brainer. So most people in the UK will have some form of personal insurance, like in case the reinstatement insurance, in case the property burns down. But if you're someone who is using that in that building in a way that you'd expect to have people in the property, then you would want public liability insurance. And that is readily available. And I would say that is the option that the vast majority of people turn to. There are reasons why a corporate will give you protection in a way that insurance won't. For the avoidance of doubt, the same argument you made about top-down creditor protection, the shares in the company you own are just as exposed to creditor as the other assets that you own. So we're talking about it from that perspective. But yes, the insurance would be the obvious solution to that answer.
But I think that's something that so many people don't think about, the top-down creditor protection and why, again, why asset protection planning, I think, at least on the US side, because we are so litigious, is really important.
So let's take it then to the sort of the third option in the UK, which is the option that most people in practice opt for, which is just holding property in their own name, because there is one other aspect to this, which probably comes up more frequently in estate planning than any other, and why I said I wanted to involve the non-US spouse in this planning process is about what happens when we have Americans and non-Americans co-owning UK real estate. And that comes to the potential taxation of the gains on that real estate when they come to sell the property in the future. Because if we have let's say we've got the family home and it's worth $1 million and it's co-owned 50% by the American spouse and 50% by the non-American spouse, when they come to sell the property in the future, they will each have a UK capital gains tax liability if they live in the UK. But capital gains tax on the sale of your main residence is entirely relieved under principal private residence relief, or PPR, in the UK. And so people don't pay capital gains tax on the sale of their main residence.
Right? We have a similar rule.
Well, you do have a similar rule, but in the US, your relief is capped, is it not, at
Yes.
$250,000? So maybe the £1 million property was a slight undercook because we need the American spouse to have $250,000 of gain in that scenario. But if their share of the property is worth more than $250,000, then we have this potential for a dry US capital gains tax charge on the sale of that property, because the UK spouse's half is entirely relieved, but the US spouse's half is going to suffer some form of US taxation. And so the options are either you acknowledge that position and you pay that US tax, or you start to look at options under which the American spouse doesn't own an equal share of the property, or indeed any share of the property at all. And instead you put the property either up front from the beginning, or maybe over time the American spouse transfers their share over to the non-UK spouse, so that by the time the sale comes around, we end up with no US capital gains tax exposure. This was, for what it's worth, so the story goes, I should say, because this is a podcast, what caught Boris Johnson out when he was an American, because he was born, I think he was born in New York, and he sold a piece of real estate, not realizing that he had to pay capital gains tax in the US. And shall we say, it caused some consternation between Mr. Johnson and the Internal Revenue Service. He had to deal with it in his own way, as he often does. with my clients, what I like to talk to them about is making them aware of this exposure and saying you might like to think about some different holding positions that end up alleviating that potential exposure to US capital gains tax.
From the US side, if you've got a, let's say, UK and US spouse, and the UK, I mean, spouse could, it's clumsy, right? But could hold the US real estate through a non-US corporation, let us say
Hmm.
from a through a UK corporation. And if they sold the shares of the UK corporation, there would not be any capital gain because those are shares of a non-US company. So that potentially could work, but it's not great. A lot of times we tend to do what you say, which is try not to have the UK spouse own that US real estate. That happens a lot. And, and figure out what other assets they have and try to rejigger that way.
I should stress, and I say this to every client or every contact whenever I talk about this potential planning, is this is tax planning. This is not matrimonial planning. If there are reasons why it is important for a couple to go own a property together, or more importantly, there are reasons why you don't want the property sitting entirely in one spouse's name, those are perfectly good reasons for keeping the property in joint names. It is only where you have a rock solid marriage and you are happy that the property sits in one party's name, that the property that shelters you and maybe your children, etc. If you're comfortable with that scenario, then by all means put it in one party's name, but not if that is going to pose a wider risk for non-tax reasons. Let's not let the tax tail whack the dog, so the expression goes.
Right. But in terms of planning, again, we have to think about, like, so where I just said where you would have it might not work, but if you did have a UK person holding US real estate through a UK corp, then that actually helps for not just income tax, but also estate tax planning. Because if they would pass away holding, right, US real estate through a non-US company, the shares of that non-US stock are not US situs assets. So again, not, complex, may not work for everybody, not telling people to run out and do this.
I think I'd like that company to be somewhere else. Maybe we
That's
choose maybe
I don't care
Cayman or
where. That's
Jersey.
yeah. I mean, I'm just for me, a non-US company, any non-US company will do.
I understand. I think basically what we've concluded is that we just need to send all of our work to the Cayman Islands or to the BVI and just put the assets in either US or the UK, or, just not own real estate.
Although I will say this, at least from a US income tax perspective, and I don't know if this works. You and I haven't talked about this yet, but I don't know if this works from a UK perspective. But there's one way that US people, it's what I'm going to call the golden goose, if you will, that a US person could not be subject to tax on their worldwide income. Okay. And it's if a US person has a non-US corporation, let us say for a moment, a UK corporation that we look at as a corporation from a US tax perspective that has an active trade or real estate business. And this is why I was kind of getting to, like, what's the rules in the UK? So if I'm a US person and I own that UK corporation with, let us say, my UK spouse. So I'm a US person, own with my UK spouse, and each of us own 50-50, or even, let's say 50-50. And it's an active trade or business from a US perspective on the real estate side. Then that entity from a US perspective would not be a controlled foreign corporation. If it's not a controlled foreign corporation from the US side, because then all of the money that's in that comes from that business, as long as it's considered an active, let's say, real estate business or any other kind of active business. And real estate is hard because it's hard to be active. But let us just say for a moment we could get there. Then if my plan is to continually reinvest in UK real estate, then as a US person, I could actually keep that money in the UK company, reinvest, 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 and until the profits are truly repatriated out to me, I will not be subject to tax on that whatever profit is there. Again, we can't just have a wad of money lying around, because if it does, potentially we end up then having what's PFIC, a passive foreign investment company, and that's bad. But this is the one situation. Now, I don't know how that affects the estate planning rules. So if I'm a US person and I own 50% or less of a UK real estate business, if I pass away holding that, I'm sure I'm subject to UK estate tax on that.
Yes, you are going to be, and whether you hold it in a company or hold your property outright, it's going to be taxed the same way. That scenario that you mentioned is the same reason why I said that we would probably choose to have the company not in the UK, because while it's great that you're going to avoid US tax, you are just going to pay UK corporation tax at up to 25% when that income and gains rolls up, which is not to say that's better than the rate of income tax you'd pay if you held the properties directly, but you've got to do a lot of rolling up before it becomes worth it. But what the viewers are actually now just listening to is Barry and me trying to find our magical scenario where we want to find an American living in the UK or a British person living in the US and paying no tax in either country. But then I guess if we wanted to not be doing that, we wouldn't be tax and estate planning attorneys. Barry, thank you so much for joining me today. It's been an absolute pleasure. I hope all the listeners have readily been able to see that you are a person who is buzzing with ideas about ways to be acting in new and fresh and exciting ways. And if you are someone who wants to understand more about these things, I'm sure that Barry would be delighted to speak to you. Barry, if viewers do want to get in contact with you, how can they do so?
Well, Aidan, first of all, thank you so much for the opportunity to be here. It's always fun to speak with you about these, for me, very exciting matters. And if you do want to get in touch with me, I'm in New York City, and I'm at Zahn Law Global LLP, and it's bzahn@zahnlawglobal.com.
And I've been Aidan Grant. It's Collier Bristow's US UK Transatlantic Tax Talk podcast. Thank you again.
Thank you.
That's all for this episode of US UK Tax Talk. If you found this discussion helpful, then don't forget to subscribe wherever you find your podcasts. If you have a suggestion for a topic you'd like us to cover, then we'd love to hear from you. If you'd like to get in touch, head over to collierbristow.com. We'll see you next time.